together. So we shall proceed. Minority leader was on the floor. About to land, I will give him the floor to proceed to do so. Please, you have the floor.
Chairman, thank you very much. Chairman, it is our view as a minority caucus that whilst there are pending cases by Her Ladyship Justice Araba Isaba-Tokono Court, we as Parliament must not be seen to be acting sub judice of the very issues she is raising in court. We are of the view that proceeding with the vetting leading to the eventual confirmation of a new Chief Justice will not be rebel within the tenets of our Constitution. We see that as a constitutional violation. Already in our view, Article 1446 provides for an acting Chief Justice in circumstances of vacancy. There is therefore no institutional crisis. There is therefore no vacuum requiring urgent action. My Lord, Justice Baffoe-Bonnie could continue serving in acting capacity until the courts have provided clarity on whether Her Ladyship Justice Araba Isaba-Tokono was lawfully removed. In our view, all that is happening does not amount to some objectivity at play. We rather see a fait accompli. Chairman, it is also our view that for the sake of our country's democracy and rule of law, the grant of 3 weeks extension for the learned Attorney General for leave for extension of time was rather unacceptable after the long delay in filing an opposition.
Chairman, please. Chairman, this has to be withdrawn. This has to be withdrawn.
Chairman,
please, we heard what he said. You clearly, you can't sit here and malign a decision of a court. It's not acceptable. It's not acceptable. Please, don't let us keep doing this, and then send the impression out there we are bad people, we are a minority trying to prevent you from. The rules are clear. You've been told the rules severally. Please.
Chairman, I'm sorry. I think that Chairman, we have to help you. With respect, we have to help you. My leader speaks at will. He speaks at will. We all know the practice in this house. Leader, you have to catch the eye of the speaker. You have to respect the chair. This attitude of suddenly punching the microphone and speaking, you are our leader, but you are a member of parliament. You are subject to the same rules as apply to all of us. So Mr. Chair, I think you should have a word with our leader.
Thank you
He
very
should
much.
seek your consent
Honorable,
before he speaks.
Honorable Minority Leader, be guided and candidly land safely.
Chairman, please.
Yes, Honorable Ayarga.
Chairman, I raise an objection to his reference to a judicial decision and the conduct of a judge. And the rules are very clear. I really don't understand why the minority leader wants me to keep reciting and reciting the rules, because everybody knows that the rules are clear. You can't say that about a decision of a court. You can't say that. So he has to expunge that.
Honorable Majority Leader, I have heard you. Honorable Minority Leader, be guided accordingly and proceed.
Chairman, with respect, what we are saying is that we disagree with the said decision of the court. And it's our right to have a disagreement with the court, most respectfully. Especially so when we are of the view.
You see, Honorable Minority Leader,
Chairman,
you can disagree, with all due respect, with the decision of the
Yes.
court. And when you disagree with the decision of the court, you know what to do.
That's not a problem. But we are making a comment, Chairman. Chairman, I've held my calm throughout all of this. I gave you my word, proud to this verdict, and I've kept my word. Today in Ghana, you cannot even speak as a parliamentarian to express a view. You will be stopped by the majority leader. I am not attacking the court. I'm saying that the minority disagrees because we have the rules book, the CI 16. When you apply for extension of time, there's a time period. You can't go beyond 2 weeks. We have the provision, so we cannot disagree with the court. We cannot cite the court's own rulings and say, on this we disagree. What is happening here? Because somebody has supermajority? What is happening in this
Honorable
country?
Minority Leader,
What
I
we
will
do-
not
what have
have
we
a
done wrong?
problem. I will not have a problem.
I have not attacked
If
any judge. We've
this
not
is
attacked the
by
court.
way of a question that will give an opportunity
fair.
for a response. You are making a preliminary comment.
Exactly, that's exactly what
Let's
exactly what
stick
is
to
being
the
done.
rules,
I don't
and
have
then
a
you
problem.
make your preliminary comment
Right.
as such.
Very well. Chairman, thank you. So we expect that steps be taken by the court to expeditiously hear the cases brought before it by the respected, learned Justice of the Supreme Court, who until removed was the Chief Justice, Her Ladyship Gertrude Araba Isaba Tokono. Expeditious hearing of this matter and a final determination of this matter will reassure the Ghanaian public that the rule of law works, that we respect the Constitution. Chairman, we submit further that all the delays in the filing of defense in the matter is a strategy to ensure that these cases languish undefended, creating space for this rash confirmation to proceed unchallenged.
Chairman.
Why?
To be off. Yes, Honorable Ayarga, let me hear you.
Why? No,
Chairman.
now you can come.
Chairman, I know now and then the minority leader will say that we are politicians and we should be allowed to do politics. Yes, we are politicians and we should be allowed to do politics. But when we sit here, our politics should be guided by rules. The rules are very clear, Chairman. The rules say that where, in the opinion of the Speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives. Impute improper motives. I repeat again, impute improper motives, or impugns the integrity of a member or any other person. The Speaker may order that the member withdraws those words or withdraw and apologize. The Attorney General is a constitutional office created in our Constitution. And he is a member of this House. In the discharge of his functions, you have no right to come and sit here and impute improper motives. Our rules are clear. What you are saying, you are imputing improper motives. Saying that all of it is a charade and then a strategy and etc. to subvert justice. No. Mr. Speaker, how can he say that? I object and I insist that that part of his statement should be expunged. And the rules are very clear that any reference to the conduct of persons mentioned in Rule 7 in any amendment, question, or remarks in a motion or on a debate dealing with any other subject is out of order. And then you, the Speaker, or the 123 Rule 3 says that if you make a determination that indeed he has impugned improper motives, you should order him to have it expunged from the records. And I'm saying that he has impugned, he has imputed improper motives, and therefore he should expunge that from the records.
Yes, Honorable Minority Leader.
Mr. Chair. Mr. Chair.
Honorable Minority Leader.
I'm a member.
Please put
Mr.
off
Chair.
your microphone. Please put off your microphone. Yes, Honorable Minority Leader. You have the floor.
Seal that to me. But he sealed that to me.
Mr. Chairman, some of my... Yes, sure. I'm saying that my colleague has a point to make. Since a point of order has been raised, I think that it was within every member's right to respond, not limited to only me.
Well, Minority Leader, with all due respect, we are a house governed by rules.
Sure, but...
I can be guided by the rules that enable the Speaker or the person presiding to take a point of order against a point of order or a response to a point of order from any other person apart from the person who raised the issue. So the rules are applied. That is why I asked the honorable member to put his microphone off, and then I'm giving you the floor to respond to the issue of the point of order raised. On the response to the point of order being raised, yes, Honorable Anymedu, let me hear you.
Yeah, Mr. Chairman, I have been quiet since morning, and I think that we must be serious as a committee. Mr. Speaker, I should think that some members of this committee have a preconceived mind, either to object to every word, every letter that is said, and we cannot continue like that. You being the chairman, Mr. Chairman, I pray, after the break, Mr. Chair, you have to steer the affairs of the committee. Now, the majority leader, please, I have the floor. The majority leader is not about, but if you are quoting the standing orders, that people are imputing improper motives, you must go to the extent of proving to us that this word is an improper motive. You just don't say it. Now, even the law that you have cited, it's on became a member of this House. Every committee meeting, people, we start, the chair, the ranking, we come out with preliminary issues before we start the agenda of the meeting. Now, if you raise a question about what I heard other people say that, well, there had been issues. Nobody has the right to raise a preliminary issue when the chairman already ruled that he should speak. This is part of us. And if every word is going to be objected to, then I don't think that we are ready for the vetting. Now, we have been here all day. The nominee had not even spoken a word. This objection, that objection, and
Honorable
yet we are getting nowhere.
You raised a point, but I feel you are out of order. It's not in response to the issue on the floor. So, Honorable Minority Leader.
It's not in response? Wow. Chairman, thank you. Oh, very well. Chairman, nowhere in my submission did I impugn improper motives, or was there an inference to such an act? Chairman, you must let the majority leader know that he is the majority leader. When you raise your objections and everybody is quiet, and you are so intolerant that you want to find a way to create chaos, I won't give you that.
Leader,
no, Chair, he was just talking.
The chair.
No, but you are closer to him, Chairman. We've all kept our calm. He is showing power, force. I am this, I am that. It's not fair. What he's doing is not fair. It's not fair.
Chairman, what the rank is doing is not right. You were given 5 minutes. We spent 15 minutes.
You don't have the floor. Honorable Dapamako, you don't have the floor. Honorable Roxanne Nelson Dapamako, you do not have the floor. You don't have the floor. Please, Minority Leader.
So, Mr. Chair, we've been very calm, quiet, decent. We want to discharge our parliamentary duties, yet the attacks are becoming one too many. Now, let me respond to him. I stated the fact that cases were filed as far back as May. It was only recently that the AG filed a motion for extension of time to file a defense and sought the leave of the court for that. It is a matter in the public domain that long after the time required to file a defense in that important constitutional matter had lapsed, the AG had not filed, the court itself had not issued a hearing notice to compel the AG to come to court until the AG requested, applied to the court for leave to file out of time. It is a statement of fact, Rich. We are not saying anything apart from what is in the public domain. So, Mr. Chairman, the majority leader must be restrained. All the confusion is being caused by him. All the confusion, I have my speech before me. I can read it again. You see?
Honorable
Chairman.
Leader.
Chairman.
With all due respect, can you conclude? If I will have to rule on the objection raised, this is what I will say. We have a constitutional mandate to vet the Chief Justice nominee. The issue before the courts, whether a defense has been filed, leave has been sought, defense has not been filed, is a matter entirely in the domain of the courts. And this cannot be a subject matter of discussion at the vetting committee. Consequently, everything said about defense or relating to that is ordered to be expunged from the record. Minority Leader, please proceed.
Chairman with respect. Chairman with respect. Chairman with respect. You are not doing justice. And I say so because everything that is happening here appears to have been well rehearsed by the majority leader with a view.
You see, Honorable Leader,
Chairman,
you have been a majority leader
Chairman,
before.
Chairman.
Becoming a minority leader, there is nothing that is well reserved.
Chairman, this approach where they will come, force you, speak, put on a mic, then you say it is expunged. What exactly, what particular word are we expunging?
I think you heard my ruling very
Chairman,
loud and clear. If you disagree with it, you know what to do.
Very
Will you
well.
proceed?
Don't worry. Don't worry. We are all aware of what this whole thing is leading to. So no problem. Chairman, we, the minority, hold a view that Article 1271 gives the Chief Justice authority to ensure effective administration of justice. Article 1272 requires all state organs to assist the courts. Yet, in the instant situation, there are no visible steps to compel speedy trial. We have not yet heard of any hearing for all cases challenging the legitimacy of the process leading to the removal of Her Ladyship Justice Araba Isaba Tokono. We believe that the acting Chief Justice wields the administrative power on this matter, and just as the injunction applications were held expeditiously, same could have applied in this instance. Chairman, it is regrettable that our motion that was intended to have dealt upon this matter did not see the light of day. We hold a view that the judiciary is not the executive's enforcement arm. It is neither Parliament's ally in political projects. It is a guardian of our Constitution, the protector of our rights, the final arbiter of all our laws. Its independence is sacrosanct. Its integrity is non-negotiable. It is the oracle of justice emanating from the people of Ghana. Chairman, for all the reasons given, including the very actions of the majority leader, basically denying us every opportunity of expressing our opinion on an important national discourse. Be it known to you, Chairman, and the committee, and the country, that we, the minority caucus, hereby vote en bloc to reject the nominee. We would want to state on record that the majority can proceed with the questions. We do not intend to proceed with any question. We are, however, registering in the strongest terms that we reject the nomination, and the records should reflect that the report of this committee be a majority report.
Woman, comport yourself.
Honorable colleague, when we show you respect, reciprocate. So far, we have extended to you every courtesy. We've heard all those unpalatable words. We've heard the abuse. So please, for posterity's sake, listen to us. We don't need to vet a nominee before we vote against the nominee. We have preliminary issues well grounded in law. You may disagree with us. And we say that on the basis of that, we cannot be part of a process that would give right to another and deny another of her bona fide as enshrined in the Constitution. Chairman, that said, we would yield to you to proceed whilst we exit this committee room with our views well documented for the records, and on the floor we shall proceed with the debate, further stating our position and take a vote against the nominee as required by the rules of the plenary. Thank you very much indeed.
Thank you very much, Minority Leader. But how do you reject a nominee who is yet to be vetted?
Should I respond?
The report is not ready to be voted for. We are not at a stage of approval. So your conclusion is very preemptive.
No, Chairman, let me
It's
Chairman will respect. Chairman would
this is not what I want you to respond to.
No, Chairman,
so
but
I don't want your
Chairman,
response on this.
To the extent that you've raised it, I just need to.
Honorable
Chairman,
Minority Leader,
Chairman,
you have your day.
Chairman,
you have your day. The two microphones should be off.
Chairman,
the two microphones should be off. With all due respect,
we have registered our position.
Honorable Minority Leader,
that we have rejected. We don't need to vet
agreed on your position.
We reject it, and we
agreed on your position. Yes.
Yeah.
When it is time for voting, then you can vote against the nominee. Yes. So we thank you very much, and we wish you a very good luck. Honourable members.
Why you wish us a good luck?
Yes, sir. Yeah, okay. Yes. Honourable members, those present here, we have the constitutional quorum to proceed to vet the Chief Justice nominee and present our report accordingly to Parliament. On this note, we will proceed with the vetting questions. And my Lord Chief Justice nominee, members of the committee will then ask you questions, and you are expected to give response to those questions. Be calm and provide answers to these questions. I will start the preliminary questions with you by asking you to tell us briefly about yourself.
Thank you very much, Honorable Chair. Please, before I answer the question, may I be expected to, may I be allowed to read make a brief opening remarks?
Allowed, you be allowed to do so after you have indicated to us who you are.
My name is Paul Baffoe-Bonnie. I'm a justice of the Supreme Court. I've been a justice of the Supreme Court since 11th of June 2008. So 17 years plus I've been a Supreme Court judge. Before the 11th of June, for 2 years I was a justice of the Court of Appeal. Before then I was 6 years as a High Court judge and 7 years as a Circuit Court judge. I was born on the 26th of December 1956. I went to Korongo Dumasi Secondary School in 1969, finished O-level in 1974 and A-level in 1976. I then proceeded to Legon, where I read BA Law from 1976 to 1979, entered the law school in 1979 and left in 1981. I was called to the bar in 1983, 2 years after I had graduated from the law school, because at the time we were being called to the bar, my colleagues were being called to the bar in 81. I was in Nigeria seeking greener pastures. I taught for 2 years in Nigeria before coming down to Ghana, where I was called to the bar and I started practicing law. As a practitioner for about 5 years in the chambers of Dr. Takiotu in Sekondi, 1 year in Sekondi, and 4 years in Kejetia Chambers in Kumasi, where I practiced with my friend, the late Sir John, until 1988 when I joined the Ghana Prison Service. I joined the Ghana Prison Service in 1988, and I underwent 6 months military training, and I was posted to Sekondi. That's where I met my wife. At the time I met my wife, he was also a Bobno rank person. She didn't have any rank, actually. A sixth former who was then starting her career in the prison service. I was with the prison service for 2 years, till 1990, when we were told that I, as a deputy superintendent of prisons, couldn't marry a junior officer because we couldn't go to the mess together. So I opted out of prison service so that she could stay. So I joined the Internal Revenue Service, where I was the legal officer in charge of Eastern and Volta regions, also for 2 years. then finally joined the bench in 1992 December, and the rest is history. So I was posted to Yamkwanta as a circuit court judge, brought to Kumasi. For 7 years, I was circuit court judge and I became high court judge, and then I'm now here. So I've been a Supreme Court judge for the past 17 years until 22nd of April when I was nominated to act as the Chief Justice during the period of the turbulence. And I'm here before you as a nominee for the position of Chief Justice. Now, if I may read my opening remarks, now that I've asked the first question.
Thank you very much. So, my Lord, beyond telling us about who you are, you indicated you have an opening remark. We've also seen your credentials. In giving us the opening remark, thank you very much. So, my Lord, beyond telling us about who you are, you indicated you have an opening remark. We've also seen your credentials. In giving us the opening remark, you should briefly describe the personal values and experiences that you believe most qualify you to serve as Ghana's Chief Justice.
Thank you.
You combine it with your remark.
Okay. Honorable Chairman, it is a profound honor for me to appear before you today as nominee for Chief Justice. The judiciary of Ghana stands at a defining moment. As I appear before you today to be vetted by Parliament, I do so fully aware that this process is not merely a constitutional requirement, it's a national reckoning. My nomination comes at a pivotal moment in Ghana's democratic journey, a moment marked by public skepticism, institutional fatigue, and a growing demand for justice that is not only delivered but deeply felt. As I step into this role, subject to your endorsement, the nation will look to me not merely to preserve the judiciary's legacy, but to renew it. The nation needs a judiciary that does not merely interpret the law, but elevates the nation's conscience. With your guidance and cooperation and that of all stakeholders, I pledge to restore confidence in our judiciary and leave it stronger than I found it. If I'm endorsed by you, I pledge to lead an era of greater transparency, efficiency, and accessibility in our judiciary. I do so mindful of the constitutional role of the judiciary, not as a political actor, but as a guardian of rights, checks against abuses, and final arbiter in the rule of law. I propose to anchor our transformation on 3 pillars: procedural clarity and predictability, efficiency and accountability, and open justice. If confirmed, I will stand with every judge, every staff, every court user, and every citizen in the belief that access to justice should not depend on who you are or your connections. The Constitution entrusts the Chief Justice not only with judging cases, but with guarding the credibility of justice itself. My task, if confirmed, is to ensure that the law remains both a shield for the weak and a restraint upon the powerful. With your guidance and cooperation, I pledge to restore confidence in our highest institution and leave it stronger than I found it. Now I am ready for your questions. Throughout my career, from prison service, through the Internal Revenue Service, and the Judicial Service, where I've been for the past 33 years. I have integrity. I've believed that everything that I've done as a judge has been done with integrity, honesty, and impartiality. I have charted a course of adjudication that believes that the law should be the law for everybody. And that it doesn't matter who you are and what you are. Once it comes to the law, it is no discriminator of persons. That has been my abounding lifestyle. And if anybody were to go through any of my files at any of these places, this is what you come up with. That this man is honest, this man has integrity, and this man has what it takes to be a leader. And I believe that I have what it takes to lead the judicial service.
Thank you very much. That is preliminary. I will then proceed to give the floor to Honorable Roxanne Nelson Kwame Eche Dapamekbo to ask questions. Honorable member, you are entitled to 3 questions. You may ask up to 3 questions.
Chairman, thank you very much. I'm guided. My Lord, you're welcome.
Thank you very much.
I wish you all the best.
Thank you.
And thank you for guiding me at the bar.
You're welcome.
My Lord, you have a very rich CV. But let me touch on a matter that is out there. What would you say to those who suggest that your nomination by the president was a reward for your holding in his favor in the 2013 election petition? It's some debate out there.
Well, I don't know. I don't know where to start from. I actually do not know. I wouldn't know what goes on in the president's mind since I'm not there. But I actually will be disappointed if my only qualification for the Chief Justice nomination is because I voted for the president in 2013. But I mean, that is on a lighter note. But I think I qualify for the position. As I said, I have been a Supreme Court judge for the past 17 years. I would not be presumptuous to say I am the best qualified person in the Supreme Court. No, I would say that. But I've been at the Supreme Court for the past 17 years. The person who has served nearest to me has been there for 10 years, meaning I was at the Supreme Court in 2008. The next person came there in 2015. The others are from 2019 and then 2020. So I think I qualify for the position. And let me add something. I was actually, if you look at my CV and if you follow the trajectory of my career, I was actually admitted, I actually was made a circuit court judge by Chairman Rollins. Then I was promoted in 2000, and I was sworn in together with Sergio Jamefe. I was sworn in by the then Vice President, President Mills. Then I was elevated to the Court of Appeal by President Kufuor. Then to the Supreme Court by President Kufuor. So if, that was 2008. So if 17 years later, another president deems it fit to eliminate me to the position of a Chief Justice, I think I cut across all political boundaries. I don't think that, I think I'll be a reason for people to say that, oh, this man is deserving of the position. Because from Rawlings, Mills, Kufuor, and then Mahama, I think I deserve the position, that's why. But as I said, the president might have personal reasons. I don't know that.
Very grateful.
Any further question?
Yes, my lord, you have a very rich and expansive CV. I see that you've done, as part of your work as a juristic officer, you have also worked extensively in election and election-related matters, chaired a lot of committees. Now, the argument is out there regarding the duration that presidential election challenges take, all the 2 or 3 that we've had so far. Will you consider, if you get the approval of this House, will you consider introducing reforms such that, for instance, a challenge can be determined before inauguration on the 7th? Will you consider that? That is between the 7th of December and the 6th of January. Will you consider introducing?
Thank you, Honorable Chair. Thank you, Honorable Chair. You see, as part of the, as you said, I have been a member of the Election Management Committee of the Judicial Service since 2010. And then I became its chair in 2020. As a part of our engagements last year, we had a lot of stakeholder engagements with IPAC. We had stakeholder engagements with the CDD, CODEO, that is CSOs, and then the Peace Council. The main theme of these meetings was the fact that in 2013, the election petition lasted for almost, it was 8 months. The final decision came on the 29th of August. Essentially, I'm the only surviving member of that panel. Everybody else has retired. The final decision came on the 29th of August because one of the first drawbacks was we spent almost 1.5 months discussing whether to even allow the NDC as a party to join the action. In the long run, at the end of the day, by a majority of 6-3, NDC was joined to the action. It was one of the greatest mistakes we made in that particular trial. And that was one of the first things we touched on after the trial. We went into a conclave and came up with a decision that, no, there was no need to join any other pegs. So CI 99 came up, and that was when we decided that the trial and everything could be done within 42 days. So discussions went on, and we agreed on 42 days maximum for presidential election petitions. And so in 2020, when there was an election petition, it was a straight fight between JDM and then Akufo-Addo at the time, and then the EC. And it took 42 days to deal with that election petition. But we know that Kenya does theirs within 21 days. The only time America faced an election petition, that was between Al Gore and Bush in 2000. The election petition, whatever it was, ended with the declaration of the new president before the inauguration. So at most of these forums or fora where we discussed the elections in Ghana, we came to the conclusion that it should be possible to have the election petition concluded before the 7th of January, the inauguration day. And the first suggestion that came, which we think was a masterstroke, was that we should have the elections on the 7th or the 8th of November. If we have the elections on the 7th or the 8th of November, by the 10th, the results would have been declared. If we have the results declared on the 10th of November, we have 20 more days before even November ends. Then 31 days of December. Then 6 days of January, making a total of 57 days. Assuming we want to stick to even the 42-day window provided by CI 99, we can have the election petition filed, responded to, and everything tried within the 42 days, because we have 57 days. That is number one. In addition to that, we can have, lawyers say that every originating motion or originating process has to be served personally on the defendant or respondent. But we all know that in this day and age, every form that anybody fills with the EC, you have to provide electronic address. You have to provide email, telephone, WhatsApp, and all that. So instead of saying that you file a petition and it takes 7 days to get to the respondent, using the electronic mail, we can reduce the number of days to, let's say, 3 days. So a process that is filed, if it is served electronically, even the originating process can be filed and served electronically within 3 days. Instead of waiting for, let's say, 1 week for the response, we can reduce the number of days for the response to, let's say, 4 days. So if we adjust times like that, by the time we get to about, let's say, the 30th of November, that is granted that we had the elections on the 7th of November. By the time we get to November ending, processes would have been, pleadings would have closed. CMC, court management conference would have gone through, issues would have been settled, and then the trial will begin. And a trial like that, we can say it should take no more than 2 weeks. And once 2 weeks are there, we say judgment should be given within 1 week on the release of the results. Meanwhile, at this point in time, during December, we have a lot of holidays. But under the fiat of the Chief Justice, the registries can be made to stay open so that processes can be filed, served, exchanged, everything can be done in such a way that we can have all these things done before the end of January, so that by 7th of January, Inauguration Day, we will have our president who will take the sword and swear to his people and be able to say, because we all know in 2013, for 8 months, the president-elect was performing his constitutional duty all right, but he wasn't too sure whether he was going to be chalked off or replaced or what. Even though the 2020 election petition also lasted for only 42 days, it lasted beyond the inauguration. So these are things that we have discussed, and we shall need the input of Parliament when it comes to LIs and CIs to be prepared. So this is what I intend to pursue so that we can have our election petitions, if any, in future. And I'm sure there will be, and before the inauguration day. Thank you, Mr. Chairman.
Thank you very much. Do you have any further question?
Mr. Chairman, thank you. That is so. My Lord, I appear to be the Lone Ranger in this matter. The welfare of the judges at the magisterial level is so dear to me. But I see a disparity in the welfare, in the service of office and conditions of office for what you term professional magistrates, that's lawyer-turned magistrates, and the career magistrates. And they do a lot of work, the career magistrates. In some cases, they do relieving in 2 or 3 other district courts within their jurisdiction. So the question is,
yes,
will you consider introducing the career magistrate program to absorb young men who are interested? Yes, reintroduce, because it will be a very heavy source of personnel. And also reforming them in such a way that they will have the opportunity of rising through the ranks to the level. Because recently you just elevated...
Honorable member, I think
finish.
you have
Mr.
asked
Chairman.
your question.
No, Mr. Chairman.
You see, today I said we'll go by the rules. A questioner is not supposed to run commentary. You don't run argument. The foundation cannot be too long. So strictly proceed to ask questions. That is the rule. So Honorable Roxanne Nelson Dapamakbo, ask question.
Chairman, I'm guided. Thank you. So, CJ nominee, will you consider reforming the courses, the career magistrate program in such a way that they will have the opportunity of rising through the ranks and getting to the highest level? Because they do a lot of work as the same as the professional magistrates. Presently, you have about 75 openings at the magisterial level. You just elevated some from the circuit to the high court. Naturally, you will elevate the district judges to the circuit court.
Thank you, Mr. Chairman. In the years gone by, when we started practicing, we had the grade 2 magistrates and the grade 1 magistrates. And the grade 2 magistrates were actually not trained lawyers. Most of them were social welfare workers, retired teachers. and the rest, they were grade 2 magistrates. And then lawyers who joined the bench, but were not 3 years, also had to work as grade 2 magistrates. Her Ladyship, Justice Avril Lovelace Johnson, was a grade 2 magistrate in Chebi. I appeared before her when I was a lawyer with IRS in Koforidua. I used to appear before her. So that was, and so, but when lawyers get to 3 years, lawyers who had joined the bench got to 3 years, automatically they became grade 1 magistrates. But with the grade 2 magistrates, the original ones, they never had the chance to go beyond grade 2 magistrate. They couldn't join the bench at any level because they were not lawyers. That was the situation of things until sometime, I think in the 90s, the whole concept of grade 2 magistrate was abolished, leaving only professional magistrates, that's lawyers who were magistrates. But then, around the 2000s, the millennium era, this concept of career magistrate was reintroduced. This time they were not called grade 2 magistrates, but they were called career magistrates. But they were doing the same thing. And this time, the judiciary went one step further. Whilst with the grade 2 magistrates, they were just social welfare persons who had retired or been drafted to become magistrates. With the career magistrates, these were even, they could be even as young as 30 years. In fact, they were the very first ones were actually workers with the judicial service who were drafted to undertake 1 year or 2 year course at the law school. So they took 2 year courses and then they were made career magistrates. But they are not lawyers. So their career path carries them only to the chief magistrate level. And that was it. It doesn't matter how long you stay there, you can get to a chief magistracy, and then that will be the end. But we still maintained the 3 years for professional magistrates. So what then became the order of the day is that these lawyers, these career magistrates, then opted to go and read law. And once they went to read law, then they could transition to become professional magistrates. But here was the problem. You find somebody who has been a career magistrate for, let's say, 7 years, 8 years, 9 years, 10 years. Now he goes to the law school, he transitions, he's a lawyer now. And because he hasn't spent 3 years, he has to remain on the career magistrate level until he becomes 3 years. He gets to 3 years. Even though he might be more experienced than somebody who has left the law school and, been practicing for the past 3 years. So there was a problem. And then again, I know, for example, in the army, if you go through the rank of, let's say, the junior ranks, the furthest you can go is maybe chief warrant officer. But in the army, you have a warrant officer who, because of longevity, maybe even be receiving a salary higher than that of a captain at a senior officer level. But with a career magistrate, it doesn't matter how long you stay as a career magistrate. You cannot run an incremental that will make you overtake a professional magistrate, somebody who has joined just this year. All these were problems but as your honorable member was saying, only about a month or so ago, we had a send-off party for a couple of our retired career magistrates. And it was when their CVs, their citations were being read that we realized that we really need them. Because these are the people who are prepared to go to the nooks and crannies of the country. Maybe you are a magician, maybe you have been following the judicial service. But the vacancy at the district court is 116 at the district court. We are not getting lawyers to join at the magistracy, at the district court. Most of them want to come to the circuit court and to the high court. So with the current elevation of some circuit court judges to the high court and the district court to the circuit court, we are going to have an opening for 116. And I can assure you, we are not going to get, no matter how often, how much we advertise, we're not going to get lawyers to come and fill these vacancies. So it is my project that I will be discussing with the Judicial Council, the reintroduction of not only the reintroduction of the career magistrates, but we should be able to have a proper remuneration regime for them so that those who come can stay. And then, again, it should be possible that there should be a law that makes it possible for somebody who has been a career magistrate for a certain number of years, if he becomes a lawyer, then he doesn't need to wait for another 3 years to become a professional magistrate. There should be a smooth transition. This is a project that I intend to pursue.
Thank you very much. I will then proceed to give the floor to Honorable Muhammad Shaibu.
Let me thank you.
You are entitled to 3 questions, strictly questions. I can assure you, my Lord, that every member of this committee may want to exhaust the 3 questions. So, strictly questions, no comment. And non-members of the committee, I plead with you to perpetually remain silent.
Chairman, let me thank you very much. My Lord, congratulations. Chairman has cautioned. But, my Lord, cost of litigation by the day has become very expensive. Legal Aid Commission came in as a stopgap. Unfortunately, they lack the resources to represent clients. So today you have in courts unrepresented litigants. Would you consider fashioning out a very simple procedure which can take care of unrepresented litigants? Thank you.
Thank you very much, Honorable Chair. The legal aid is an orphan. The legal aid board is an orphan, like the prison service. Now the prison service, they are getting some parents, but the legal aid remains in the doldrums. It is true that cost of litigation is now very high, and it's become very, very high, higher as a result of the delays that are occasioned in the courts, so that even small, minor offenses in the criminal realm, small claims in the civil realm, still have to follow a long queue. So litigation is now very expensive. And when you look at the persons who patronize the legal aid, you realize that, but for the fact that they don't have the means, they wouldn't go there, because they are very much under-resourced. So it is something that I have discussed since I started acting. I have discussed with the Attorney General, and we are trying to find a way of resourcing the legal aid. As a matter of fact, with time, in the long term, we are thinking of even mobile courts, which will be able to take care of some of these things. We are thinking of, I was telling somebody that maybe the president even stole his the 24-hour economy idea from the Judicial Service, because we have planned for some time now to introduce courts around the clock so that we can have night courts. And then, see, all these are supposed to augment the legal aid situation. If there are courts around to take care of cases, definitely the cost of litigation will go down. So apart from asking for more resources, which I have discussed with the Attorney General, we are thinking so much about other things like having night courts, weekend courts. Already we have weekend courts to take care of electricity and other things. So once we do that, we hope that, and then to cap it all, the ADR, ADR is something, an avenue that we want to highlight. Already we have court-connected ADRs, and then we have set aside weeks, 1 week in every term, to have ADR sensitization. But people are still not sensitized enough to resort to ADR in some of their claims. So we have a combination of plans to get rid of, to resolve the legal aid and also reduce the cost of litigation. Thank you.
Thank you very much. I recognize a supplementary question from Honorable Mahama Yarega, the leader of the House. You have the floor.
Thank you. So, my Lord, do you have your commitment that your court will now say 24 hours when you become Chief Justice? Judiciary at 24 hours.
I said we are exploring. Already we have, we
want to pin you down to a specific commitment to this committee that the courts will explore and will sit 24 hours and provide opportunities to citizens to pursue justice 24 hours.
Well, it is possible, but for now, we have some courts that have morning shifts and afternoon shifts. At least for now, we have that one. And we have some courts that sit over the weekends. So it is now left to us to, so we can say we have a 16-hour economy. It's now left to, with time, maybe we will get to a 24-hour. I'm certain the president stole his ideas from us.
Thank you very much. Honorable Shaibu, do you have any further question or follow-up on this question?
Thank you, Chairman. A further question, not a follow-up. Yeah.
That is your question number 2.
My Lord, let's still stay within justice delivery. A very important aspect of how we live. Cases on appeal. I mean, previously, if you're up country, Bolga, Wa, Tamale, you would have to travel to Accra for Court of Appeal cases. I note that there was a system in place that cases were heard in Ho, Kumasi, Tamale, and Cape Coast. This, for some time now, has not been working, or it has been suspended. Would you consider that Accra is not Ghana, and that many regions still will have to travel to Accra to the Court of Appeal? Would you consider reinstating and possibly expanding that service to all regions of this country? Thank you.
Thank you, Mr. Chairman. I think with all due respect to the questioner, I think the question is not factually correct. Yes, we used to have Court of Appeal sitting in certain regional capitals that are not, where we don't have them now. But it is not true that all the other regions have been suspended, no. Now we have a Court of Appeal in Accra, as usual. We have a Court of Appeal in Kumasi, where we have accommodation. So they are residents there. The judges, there are 10 judges of the Court of Appeal who are in Kumasi, residents there, dealing with cases in the Ashanti region, Brong-Ahafo, and the north. We have 5 dedicated Court of Appeal judges for Eastern and Volta regions. I mean dedicated in the sense that they are assigned to only the Court of cases from Eastern and Volta regions. So the Court of Appeal sits in Koforidua. Then a Court of Appeal sits in Sekondi to take care of Central and Western regions, and then the Western North. So we have at least 4 courts of appeal. That is Accra, Kumasi, Koforidua, and Sekondi. These are the 4 places that we have our cases. But whilst because there is accommodation for the judges in Kumasi, they are resident there. The dedicated 5 for Eastern and Volta are living in Accra, but they go to Koforidua 1 week in a month. 1 week in a month. They will go and sit there 1 week in a month. Then those who are for Sekondi also go to Sekondi and deal with cases 1 week in a month. Now, Tamale and the North don't have resident judges there, but they are also served by the judges in Kumasi. But you see, because of distance and then even costs, any time the 5-member committee, judges, the panels goes to Kumasi, goes to Sekondi, the service spends 38,500 cedis or 40,000 cedis on them in terms of hotel accommodation, transportation, and all other logistics. Koforidia, if the 5-member go, it's the same thing, around 40,000 cedis. But you see, going from here to Koforidia is so easy, even though it is risky and inconvenient. It is so short. The Kumasi people found it very difficult to go to Tamale, where they would meet the judges. So they were doing virtual hearing. The virtual hearing was started at the time of COVID, and we realized that it is a very good way of doing things. So Kumasi and the North were communicating only by virtual hearing. And then, but when I started acting, I realized that the virtual hearing was not very convenient because of the interconnectivity. There were breaks in transmission and other things. So I actually spoke to the Judicial Council. We went to see the Minister for Communications, that is Honorable Sam George. And now we have the interconnectivity is so good that even now we don't go to Sekondi again. We do virtual hearing of appeals for Sekondi. So now instead of incurring 40,000 cedis in a month, we do virtual hearing. So it is something that the lawyers are very, very happy about. For now, the judges stay in Accra, and then the parties meet in Koforidia. So even if the lawyers in the case are in Accra, they still have to go to Sekondi to take part in the virtual hearing. Now, what we are aiming at is a situation where we can have persons, for example, Kofodia and Ho. We are trying to get to a situation where lawyers will not go from Koforidia, Ho to Koforidia, but they can also have a hearing whilst they are in Ho, so that the judges will be in Accra, the parties could be in, one of the parties could be in Koforidia, another party will be in Ho, or Cape Coast lawyers can sit in Cape Coast and listen in and take part in it. That is a long-term project, but for now, the regional capitals are taken care of by way of virtual hearing.
Any further question?
Yes, Chairman.
Please do.
I see my lord is getting into virtual stuff. So let's move on to empaneling of judges at the Supreme Court. First of all, what goes into the thinking when you are empaneling judges? And given that the human element of it raises some questions, would you consider looking at an automated system of empaneling judges at the Supreme Court? Thank you.
Yes, my lord.
Thank you, Honorable Chair. Empaneling creates a lot of anxieties among people. There are lots and lots of people, suspicions about for judge shopping, persons who are, some judges are not empaneled and other things. I think to get rid of such suspicions, we should be able to consider AI to do that. I am not very AI, but I know that those who know about AI tells me that if you are able to feed the computer or AI with information about judges, their philosophies and everything, the AI should be able to do empaneling based upon the things that we have fed it with. And I think it is done elsewhere, so we can try it. But what actually goes into the used to go, I wouldn't be able to say for some time now what. But when I joined the bench, when I joined the Supreme Court bench, we were about 16. And then when at the Supreme Court, we know everything is based upon seniority. We have persons we refer to as seniors. Then we have the middle, and we find the juniors. There is no derogatory. None of the words is complimentary or derogatory. It only shows when a person was appointed. So I will be the most senior. It doesn't mean I'm the best. Somebody may be the most junior because he was appointed to the Supreme Court only yesterday. But that is how we had this classification. So any case, we had the seniors. So any case that we wanted to empanel, you find one senior. Since we sit in panels of 5, we have a senior, we have 2 middle, and 2 juniors. And that makes a panel. And it was done randomly. There were situations where if we are sitting in 7 and we want to believe that this is a matter that we should get the seniors to sit on, then it is that can also be done. I remember in the 2013 election petition, the empaneling was done in such a way that the Chief Justice opted not to sit on it. Justice Datiba had only 4 months to go on retirement. And since we were not too sure how long the whole trial was going to take, he opted out. Then it was number 1, number 2, number 3, number 2, up to number 9. So it wasn't like somebody had been handpicked from somewhere because of this particular reason or the other to do it. So empaneling is normally done randomly, or it follows certain patterns. But because of the anxiety it creates among people, the suspicions, or people feel it's not transparent, I think we should be able to consider AI empaneling. But in our part of the world where a person can decide not to sit just about 2 or 3 hours to time because the wife is being taken to the hospital or the father has just died, it means AI will find it difficult to replace such a person. Maybe AI should be told that, okay, instead of 5, set aside 6. So when somebody opts out, you can bring the 6th person in. So AI will be a very good thing for empaneling. Thank you very much.
Yes, Honorable Shaibu, your very last question.
Yeah, exceedingly grateful. Exceedingly grateful, Chairman. I see my Lord has veered into AI. Can we apply AI again or any other method? Backlog of cases and then delays. What concrete steps and time-bound steps would you want to employ to deal with backlog of cases that are hanging and speedy trials? Thank you.
Thank you, Honorable Chair. I think to tackle the backlog, to find a way of clearing the backlog, we must first identify what causes the backlog and then the delays. In the first place, litigation, courtroom litigation the volume has increased, whether we like it or not. Now, people litigate practically over everything. In the years gone by, I'm sure if you took my picture and you displayed it in your newspaper, and so I'll be very, very happy if somebody came and, Daddy, I saw your picture somewhere. I will see it as even you promoting me. But I'm certain that if you displayed my picture in your anywhere else, maybe even in your house, and without my permission, I will sue you. So now people sue practically over everything. Intellectual property and everything. So the courts are inundated. That is number one. We've tried to solve that problem by opening more courts. But the more courts that are opened, the more the litigation comes up. Some time ago, we had courts up to Medina. From Medina, you could only go to another court on the mountains. Then we realized that we have to have a court at Adenta to take care of that enclave. Now, courts in Adenta have more cases than courts in the law court complex. The threshold for every court should be about 250 cases. At the last count, the High Court 1 in Adenta had 849 cases for one court. So the cases are many. There are more cases. So it doesn't matter how hard you work. You find you deal with one case and 2 more cases are added. Then we have situations which I will refer to as, institutional. CI 47 was actually passed in 2004. Those of us who were practicing using the older version of the rules, that was LN 140A of 1948 or 1950, 1960, 1954. LN 140A of 1954. Between 1954 and 2004, when the new CI 47 came, lawyers were always referring to the White Book of London, of England, which had undergone several editions. But we still had our LN 140 of 1954. By the time we had the CI in 2004, CI 47, it was already dead at birth. It was outmoded at birth. So we have rules in the CI 47 which make it impossible for us to move forward. In this day and age of electronic e-service and everything, we still say that when a person issues a writ, it has to be served within 8 days. Now we have the Electronic Act, which makes it possible for you to do a service electronically. But the rules insist that as far as the originating process is concerned, it has to be served personally. So in this day and age of when everybody fears for his security, we still have bailiffs going around serving processes. So if we improved the rules, we have situations where applications that are filed, applications are filed and they stall proceedings in the trial courts. All these things are catered for by the rules. So if we are able to review the rules, and that is one of the things that I intend to do, to engage the Rules Committee, the Attorney General's Department, the Attorney General, not Attorney General's Department. I will be on his neck, and then I'm not going to kill him. I'm not going to kill him. I'll be on his neck, and then with the Rules Committee, so that we should be able to amend the rules to make it user-friendly, to take care of the technicalities so that trials can be sped up. As for the cases that are already in the back, that have been clogged, what we can do is that we should be able to track. Now we have a monitoring team, which I'm going to reinforce, that goes about tracking backlog cases that are locked up, and then we will see what we should be able to do about it. This is not to say that there are no human elements in this. Lawyers play all kinds of games to have cases delayed. They play all kinds of games to have cases adjourned. I remember when I was appointed a Supreme Court judge, and we were attached to the American Supreme Court. They were surprised that we could grant adjournments on the ground of somebody's wife, and because a lawyer says, my wife is being taken to the hospital. The judge asked us, are you a doctor? If your wife is going to deliver, you are the doctor, you don't need to be there. you have to come to court. And that is their system. But here, sometimes you have somebody coming to say, my father has died. 3 years later, he's asking for adjournment, and his father has died. 4 years later, the same father has died. How many fathers you have, you cannot really tell. So we see there's a human element to this. But we are going to work on all these so that we can have a reduction in the backlog of cases. Thank you, Mr. Chairman.
Thank you so much, my Lord, the Acting Chief Justice, and the nominee before us. We have 6 more members to ask you a question. Therefore, we will plead that the brevity rules that apply to members would apply to you, mutatis mutandis. So I will call on Honorable Haji Aladi to ask you a question.
Thank you, Chairman. Chairman, let me take the opportunity to congratulate my brother on his being nominated. From your narration, you have clearly stated that you've come a long way through so many governments, presidents, vice presidents, and what have you. That is actually a basket full of a lot of experience, and your CV tells it all. However, although you are acting, you are now going to be the substantive, inshallah. My question is, as Chief Justice, you will preside over a Supreme Court with diverse personalities and differing judicial philosophies. How will you foster collegiality and prevent personal disagreements from undermining the administration of justice? Thank you.
Thank you, Honorable Chair. Well, Honorable Chair, by its nature, the Supreme Court is collegial. When we say collegial, we mean, unlike let's say, the District Court, the Circuit Court, and the High Court, we sit in colleges, we sit in panels of more than one. So, and then we take decisions together. There is no, every judgment that is delivered that you read about, even though it comes under the hand of one judge, you can be sure that it has been decided by the panel members. Unless there is a dissenting opinion, it is the opinion of the judges. So that is why we say it's collegial. We go into a college, we call a conclave, and then we come up with decisions. You are right. I come from Gozo. The person who is now the president of the court comes from Navrongo. We have somebody from Wa. I went to the best secondary school in Ghana, Korongotuma Secondary School. Somebody went to one of us went to a school which is no longer even in existence. Sir Dennis went to a school which at the time was a mixed school. Now it is a girls' school. Achimamai Secondary School has now become a Fiakobi Girls' Secondary School. So he doesn't even know whether he's an old student or... So...
My Lord, he's still an old student. And the school is still in existence.
And then there is this Wa man who went to school at Goforidia, the town of the flowers. You see, so you are right. We come from different backgrounds, different schools, different philosophies. Some of us, I mean, a couple of us, about 3 or 4 of us, started from 2 of us started from the magistracy. Her Ladyship, Avril Lovelace Johnson, started from grade 2. Sergeant Jamefe started from the Regional Tribunal. So both below the Circuit Court where I started. And then there were some of us who joined at the Court of Appeal, like I said, Dennis. Justice Puaman joined at the Supreme Court. Justice Yodi Kulendis joined at the Supreme Court. We have persons who have come from the academia, like Professor Mensa Bosu. So we have different philosophies. This is the Supreme Court. And so when you have all these people with different backgrounds having to come together and then agree on something, even with all due respect, you see how lawyers agree or disagree. The little that we saw from the Honorable Deputy Speaker, Honorable Minority Leader, and Honorable Majority Leader, 3 very able lawyers agreeing or disagreeing on the rules, the standing orders. It shows that once we come from different backgrounds, we will have different approaches to things. It could be our strength, but it could be a weakness. As a Chief Justice, your ability to harness all these into something concrete, that is what leadership is about. That is what you should, if you are able to do this, and you should be able to discuss things formally and informally before things escalate. You should be able to do things. Even empaneling can create problems among you when somebody feels that this man is not being empaneled. I wasn't empaneled for close to 1 year, even though I was the number 2 after the Chief Justice. I wasn't empaneled. It can create problems. But as a leader, you should be able to manage all this. And then you should be able to manage all this. And even though I'm talking about collegiality and then the need to have a consensus, that should not be the final thing. You should be able to encourage parties, judges, to air their views. Dissent should be encouraged. It is always better to have a consensus on everything. But if you can't have a consensus, you should be able to, if somebody says, I'm going to write a dissenting opinion, you should be able to write a dissenting opinion. You should be able to encourage the person to write a dissenting opinion. It is a way of fostering unity amongst yourselves. And fortunately, again, having been here for so long and having been here, having dealt with all the members of the Supreme Court bench now, I happen to have personal relationship with every one of them. Every one of them. Those who used to appear before me when I was a High Court judge, like Justice Yodi Kulendis, Justice Puaman, they used to appear before me when I was a High Court judge. Justice Dennis used to appear before me when I was a Circuit Court judge, and he was a lawyer in Kumasi. And then Justice Ajay Frumpong was a junior to my very, 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 very good friend called O2SL, who has passed on. So when I was even sitting as a High Court judge in Kumasi, he was appearing before me. So I have this relationship with all these judges that makes it easier for me to be able to bring them all together. So I will be able to do that. Thank you.
Thank you, Honorable Hajaladi. You have a further question?
Yes, please, Mr. Chairman.
Please do.
Mr. Chairman, there is a very big issue that is worrying a lot of us when it comes to getting maybe people who are brought before the courts so that the judges can handle them very fast. Cases are not taken up very fast. So because of that, you find our prisons choked with a lot of people, some even just because they have stolen a bunch of banana on remand. You simply can't understand. And if you look at them, when people show you such pictures, it's horrifying. Will you consider ensuring that we have at least these community courts, the tribunals, working very seriously, and you applying the 24-hour economy as you have said earlier on, so that such people can be given community kind of punishment just to deter them, rather than pushing everybody to the prisons? Because recently, just 3 days ago, just 3 days ago, I got a message that someone went to court and then was told that the judge had put to bed, so she was not in court. Now, when is she going to come out, let alone to look at it? And I don't know whether it will be passed on to another judge or that case has to wait. So will you consider ensuring that the tribunals come up basically at all the best places that you can think of, so that such cases would be handled or fast-tracked? Thank you.
Yes, my Lord, your response.
It looks like you are speaking the language of my wife. My wife has maybe engaged you to ask questions about the prison service. This is something that I know about, because as I said, I was a prison officer. And since my wife is also there, I know. For example, I am told that the inmate situation in some prisons was built, the capacity for some prisons is 851, 851. As of today, they are 3,562. A variance of 2,711. Kumasi male prisons was built for 416 persons. As of today, they are 1,727. And this is replicated all over. The prisons are choked. The prisons are choked. Remand prisoners, I mean, it is a bother. And one of the causes of the prisons getting choked is people being remanded, and sometimes indiscriminately. That is why, and then there are also some, as you said, who have committed minor offenses, who shouldn't be there, but they are there. So I think that it was particularly for these minor offenders that the Justice for All program was introduced. And for some time now, maybe because of the turbulence, this year, they have not actually even sat. It is something that I want to reignite, revamp it, so that we can have the justice for all back on the road, so that we can get rid of some of these persons. But apart from saying this, I also want to say that, Honorable, there are some people in the prisons who have been granted bail, actually. They have been granted bail, but they are still there because they can't meet the bail conditions. And not that the bail conditions are too high. Sometimes they are too high. But in most cases, they are not. In so many cases, they are not. And so you find somebody in prison, somebody on remand, who has been on remand for 5 years, 3 years, 4 years, 5 years, and those of us outside will say, if this man had even pleaded guilty and he had been convicted, he would have spent only 3 years. But because he pleaded not guilty, he's on remand, and his case is not being tried, and he has spent 5 years. But that is not the fault of the judge. If you appear before the judge and you say you are not guilty, you are not guilty. The judge says you are released on bail. But there are some people, unless you say they should sign their own bail bond, they can't get anybody to come and bail them. Unless you release them on their own self-recognizance, they will not get anybody to come and bail them. I mean, there are some of them, and as a judge, we have conditions to grant bail. The main condition a judge looks at is, this man I'm releasing on bail, is he likely to come and stand trial? The person who is making efforts to run away because he has gone to see some foreign embassies to seek asylum, he's trying to run away already. The man has been granted bail once and he didn't appear. And so if a judge decides that, no, a person like that, I'm not going to grant to bail, it doesn't matter the offense that the person has committed. The judge may not grant bail. But even if the judge wants to grant bail, he will not give you bail on self-recognizance. So persons like that, they will not get people to stand surety for them, and they will be there. So while admitting that there are some people who shouldn't be there, there are also some people who are there because they have to be there. And Honorable, we are always talking about a bunch of plantains, a crate of eggs. My mother is a Catholic, was a Catholic. I always tell this story. My mother was a Catholic. And you know, these old ladies, how when they said, in my time, the Catholic priest was a white person. So at the end of the year, my mother wants to go and then harvest a particular plantain that he has nurtured over the year. My mother was going to the farm every morning with a bent back. This young man was sitting under the shady tree. In our place, we call it in Kwankwanuase, playing drafts. Every day, my mother passed by him to go to the farm. Now, 1 year on, it is time for harvest. My mother wants to go and harvest the plantain to come and give to the reverend minister, the white priest, who speaks Latin. And then this young man has gone there. And you know, when they go there, they don't cut the plantain. They move it from the top. So my mother will walk all the way to the place before realizing that the plantain has been harvested. We sit in Accra here. When a magistrate at Gosu decides to send the boy to prison for 3 years, we sit in Accra here and say the man stole only a bunch of plantains. Do you know what it means to, what the bunch of plantains means to my mother? It's like stealing your car. You see? So, I mean, there are so many reasons. The magistrates and the judge, they are trained. They have this, the sentencing guidelines. They have them. But sometimes they have to go beyond it. In my youthful days, I gave somebody 70 years. Atayi, I gave him 70 years. And what I told myself was that if Atayi was given 30 years and he comes back, my family will be the first family he will attack. So by the time he comes back after 70 years, I'll be dead and gone. So you see, then we are thinking about community service. Yes, there are some people who, if you give 3 years, 4 years, touch wood, if I am convicted and sentenced to 4 years in prison at Nsawam, I may not eat prison food for even a day. I will have some people bring food to me. So if you want to make me feel the prison punishment, prison sentence, then maybe you should order me to go and do community service. Maybe around the place where I stole, or around the courts, that they'll see me. Because punishments are not only for the person, the victim, or the person being punished, but to deter other people. So community sentences should be introduced. But that one is in your bosom. It's a law. That one will have to be taken up by you. Another way of decongesting the prisons is through the parole system. People should be able to go out on parole for exhibiting good conduct or whatever. So if the parole system is introduced, I'm certain we can reduce the numbers in the prisons considerably. But, parole system, you cannot do that without tackling the social welfare angle of the parole system. You have to beef up, because I know in some jurisdictions, when a parolee or a person who has been granted paroles may not even be able to go beyond a certain distance because he has a tag that gives AI alarm to somebody. We don't even have these things here. So, Honorable, we are at it. We will play our part by reducing our pension for imprisoning people. We will curb that pension of giving long sentences. I'll talk to my people, because any long sentence person you send to my wife, I get a knock. You allow these people to come here, and they are disturbing me. So, Honorable, that is what we are going to do. Thank you.
Thank you very much. Honorable Ladi, do you have a supplementary question, or you want to ask your last question?
Thank you, Chairman. I want to ask my last question.
Thank you very much. Proceed to ask your last question.
Mr. Nominee, during your presentation, you mentioned places where we can find courts of appeal. Unfortunately, I sat really feeling very bad, because I would say I come from the northern sector. And I have continuously heard my people crying when they have any case that needs to go to the appeal court. They would have to travel as far as to either Kumasi or Accra. I have listened to you carefully and heard you talk about infrastructure and the way monies have to be spent, which is quite a difficult one. Will you consider putting up at least one with all the amenities that are needed to take care of the 5 regions of the north to ease problems of our people having to travel these distances?
Yes.
Honorable Chair, Honorable Chair, it is possible, it is feasible. We have done it before. We have done it before. You see, I know how sentimental people feel about such things. When I started acting, I got a letter from a community, and they said they wanted, it was written so beautifully, they wanted a district court. So I gave it to the court's services manager to advise me. And you know what? He came up with the fact that the community they are talking about, they are 500 people. 500 people. And then he mentioned the various courts that are close by. And we found that almost all those courts have cases no more than 10 a day. Sometimes the whole week. It is not, when we tried the Court of Appeal in Tamale, we realized that all the cases could be heard within a matter of 2 months. All the cases. So it is just not feasible having 5 judges stationed at Tamale to take care of the north. This is not just because the number of cases that come from the various regions put together is not up to much. So, to prevent this situation where lawyers and parties will be coming to Kumasi or Accra, that is why we are introducing the virtual, so that they will be meeting in Tamale. The lawyers don't need to, with virtual hearing, the lawyers don't need to move at all. They have to be in Tamale. So, as I said, if you have a case which is being handled by a lawyer from Kumasi, for now, the lawyer will have to travel to Tamale to go and be in the Tamale courtroom where the virtual takes place. But as I said, we are working at it. In a matter of time, we have find ourselves in a situation where some of the parties and the lawyers can be in Tamale courtroom, whilst some other lawyers will be in Kumasi, and they will be hearing cases. This is done. When international arbitration takes place, people hardly travel from here to London for international arbitration. They do virtual hearing. So that is what, if it becomes necessary for us to station judges permanently in Tamale like we have done in Kumasi, we will do that. But Honorable, you have to help us get accommodation for them.
Thank you, Honorable Ade. You have exhausted your 3 questions. On this note, honorable members, our revered guests, it is in the interest of all of us to take 20 minutes health break. Well, Hajia, you have the floor for 1 second.
Thank you very much, Chairman. So, my brother, I wish you all the best. When my colleagues were leaving, you would have heard them. It's normal of me to say, I wish you all the best. May the Almighty Allah guide and protect you.
Thank you.
So that you will be able to do your work as expected.
Thank you.
And to the best of your knowledge and to the development and progress of Ghana.
Thank you very much, Honorable.
Have a blessed job ahead of you. Thank you.
Thank you so much.
Thank you very much. We shall resume our seats exactly 10 minutes after 5 o'clock.
built but not occupied because we don't have the personnel. But that is not to also mean that we should throw our hands in despair and say that we can't do anything about it. Admittedly, there are some cases that do not move fast as a result of, as I said earlier, the technicalities associated with our rules and other things. But there are also, we also recognize the fact that there are some judges and magistrates who do not put up their best. And all these add to the creation of backlogs. And I also mentioned earlier that people are now too eager to go to court. And so we want to, as we want to build courts to take care of the more cases that are coming up, that we also want to encourage ADR. I was at the ADR week in Koforidua, and the report that they gave us that of about 600 cases that came, about 470 or about 480 they were able to solve them through ADR. And so we realized that if but it is still not, people still do not know so much about the ADR. So if people are sensitized enough about ADR, they will embrace it and then leave the courts for more serious matters. The other thing is that there are some people who, no matter what, will want to go to the regular courts. They want to have their pound of flesh. But so it's a combination of a lot of things that lead to this backlog of cases. And that is what people's confidence or trust in the judiciary going down is more as a result of the fact that their cases are not heard early. There are some people who also have lost confidence in the judiciary because they say that judiciary is corrupt. How they come by that decision, that statement that judiciary is corrupt, I have made mention of the fact that the judiciary is as corrupt as the people who man it, and the people who man it are as corrupt as the ordinary Ghanaian. The ordinary Ghanaian goes to the bank and he is told that give your money to the teller, otherwise you may have your money stolen. He goes, and instead of being in a queue for just 2 minutes, he sees somebody sitting down there, or somebody recognizes him and says, "Oh, I'm a teller." And then he takes his money to go and deposit for him. Before he's aware, the man has stolen his money. The ordinary Ghanaian goes to the courts, and I tell you, if 100 people evince the intention that they are going to see a judge because they have a case in the court, less than 3 of them will be able to go to the judge personally. They will go through his girlfriend, they will go through his wife, they will go through his friend, they will go through all kinds of people. So anybody who they think is close to the judge is game. You go and give your money to a court clerk or anybody. There are some people actually loitering around the courts who the court clerks, they know them. We have people we call bail contractors. All kinds of people patrol the courts. So you want to see why you want to see a judge because you have a case there, only you know. And then you cannot go and see the judge because you are afraid. Then somebody tells you, "Oh, that I saw the judge talking to that lady." So it is his sister, it is his daughter, it is his girlfriend. So go and see her. So people give their monies to people And then they don't even, once they have given the money out, they have bribed the judge. They have given, I mean, they are okay. So such people go about saying that, oh, the judges have taken their money. And once the judge has taken their money and they get their judgment, they are okay. While the judge has taken their money, they lose their case, and then that's when they start talking. So that is not to say that there are no bad notes among us. There are. But these are the reasons why people's confidence in the judiciary is sinking. And I intend to, once we know the causes of the decline in then we can tackle it. So if we sensitize people about ADR, that there's not every case that should go to court, mainstream court, and we sensitize people about ADR, people will go there. The backlog will reduce. If we review the rules, as I suggested earlier, it will affect even the trajectory and the speed at which cases are heard, and it will improve. And if, as I said, since there are still some bad notes, if we catch the bad notes and they are disciplined, then it will serve as a deterrent to people, to other judges. So we are going to, as it were, reinforce the disciplinary measures. The Judicial Council is going to take up this up because we already have a complaints unit, but people don't even complain there any longer because sometimes they feel that they have complained and they don't get good responses. I'm going to reignite the whole thing, reinforce it, so that, because we should get, the judiciary should be able to get the confidence of the people back. Otherwise, we might end up having people say that, well, I'm not going to court, I'm going to do what they call mob injustice. Thank you.
Any further question?
Thank you. Having listened to you, I want to find out, will you reinstate the electronic case assignment, which was introduced to keep judge shopping and later discontinued by your predecessor?
I think I am all for it. I am all for it. It is going to be reintroduced. I think about 2 or 3 years, for about 2 or 3 years now, we have a situation where applications that are filed do not have return dates. You go there, they say date to be fixed. Immediately so we found there were situations where a case comes before us, an application, even before the Supreme Court, an application comes before the Supreme Court, and we realize it is virtually moot because the application, which was actually time-bound, had date to be fixed on it, and it has been fixed for the past 2 years. So immediately I came, I said that one was wrong. So every case that is filed, every application that is filed should be brought to my attention so that we fix, because most applications are time-bound. And so I did that for some time. And now things have stabilized. So we don't have dates to be fixed again. We now have dates given to applications that are fixed for hearing. So with substantive cases, we are going to reintroduce it used to be there until the machines broke down, the system went off, and then it was allowed to fall into abeyance. Now we have actually started doing the electronic.
Thank you very much, Honorable Umar. Do you want to ask your last question? Yes, please do.
Thank you, Chairman. My Lord, there are persistent concerns out there that the current process of appointing judges and chief justices give excessive influence to the executives. What reforms, if any, would you recommend to make the appointment process more transparent?
Thank you, Honorable Chair. I think I'm the wrongest person to ask this question because, as I said, I have had my elevations across political divides. But I think the current system, for us, it follows the Constitution. If the Constitution is going to be amended to give us a different mode of appointment, then that's it. But the current system with Superior Court judges up to Court of Appeal, they are appointed by the Judicial Council, by the President, in consultation with the Council of State on the advice of the Judicial Council. And the Judicial Council is made up of persons, apart from 4 nominees of the presidency. We have the JUSAG represented, we have the lower bench represented, we have a High Court representative, Court of Appeal representative, a Supreme Court representative. We have institutional representatives like representation from, let's say, the police, the army. These are all members who come from different backgrounds, and they have contributions to make. And they advise the nomination or the nomination appointment of members of the court up to the Court of Appeal. So, and when it comes to even selection of nominees for the president to appoint, we have persons who are mentioned by the Attorney General, who is a government person. And then we have the Chief Justice also bringing nominees. And then we have the Ghana Bar Association also bringing nominees. So what happens is that there is a list produced by these 3 groups. The Chief Justice normally bases his or her nominations on seniority at the bench, performance, and other things. Maybe if a person has disparate proceedings against him, that's a different matter. Then the Attorney General also nominates, and then the Bar Association have the chance to nominate persons from the bar and also from the bench. The idea is that the bench, our performance is also always reviewed by the lawyers, by the bar. So we have a situation where when these 3 lists are produced, you find a particular, let's say we want an appointment to the High Court. you will find a particular circuit court judge whose name appears in the list of the Chief Justice, in the list of the bar, and in the list of the Attorney General, because the bar is the beneficiary of the efforts of the judges. So the judges make recommendations. In the same way, when lawyers appear before us, we know those who are good and those who are bad. And we also know those who have the temperament and the demeanor and everything that can make them judges. It's not every good lawyer who can be a judge. So sometimes we on our own. I have mentored so many lawyers, and I'll tell you, I can tell you that you will be a good material, so apply to join the bench. So even though the Chief Justice normally nominates from the people from the bench, the Chief Justice could also nominate somebody from the bar. So when these nominations are done, you go to the presidency, and then even though the wording is that it is done on the advice of the Judicial Council, and the Supreme Court has said that the Judicial Council's advice doesn't bind the president. Nevertheless, I have been a member of the Judicial Council, and currently I am its chair, acting chair. If 40 people go through our net at the Judicial Council, less than one or a maximum of 2 may not be taken by the presidency. So the advice, we say it doesn't bind them, but in reality they listen to us because the president knows that it is the Chief Justice and the Attorney General who deal with these people. So if they make this advice. And so with this kind of nomination from these 3 people, how people can talk about political, I can't really understand. With the Chief Justice, over the years, this is how it has been done. It is I think, well, I know in Kenya, things are done differently. The Judicial Council or Judicial Commission is very empowered. But whatever it is, the presidency, the president has a say. And at least that is what our constitution says. If Ghanaians believe that the constitution should be changed to give power to other persons, other bodies to nominate their Chief Justice or the President, Supreme Court judges, then they can lobby the Parliament for honorable members to have a look at it.
Thank you. Honorable members, on this note, we will then proceed to take questions from members of the subject matter committee in line with Order 217. Honorable members, subject matter committee members can ask 3 questions, but they are only entitled to 2 supplementary, if any. So, Honorable Bede Asidin, you have the floor. The name is Bede Asidin.
Thank you very much, Mr. Chair. I was going to correct it because you are putting the wrong name to go into the Hansard, and I object to that. Anyway, thank you very much for the opportunity. My Lord, congratulations for this nomination.
Thank you.
And I think that you deserve this nomination. You have served this country for such a long time, and I believe that what is happening today is the icing of the cake. And
thank you very much.
We will proceed to ensure that you enjoy this cake. Let me also use the opportunity to thank you for the guidance that you provided me whilst I was in practice. I appeared before you a couple of times, and I think that I was impressed with the way and manner you guided me throughout. I didn't stay there for long and came out to my political field. But I appreciate what I got. Thank you very much, my Lord. My Lord, I have a few questions, and I will send you back to the issue of the appointment of judges to the bench. And as you have already stated, this has been provided for under Article 44 of the Constitution. And that provision gives the President the power to nominate and appoint justices of the High Court, Court of Appeal, Supreme Court. Yes, there are certain processes that go through, but ultimately, it is the President that we see. That's what the Constitution has provided for. He does the nomination and he does the appointment as part of all that. We have tried to explain that even though...
Honorable, you are violating our rules. Please ask question.
I'm asking the question. I'm laying the My mic is... My Lord, I want to find out from you, do you agree with the current arrangement in terms of the appointment of judges to the High Court, Court of Appeal, the Supreme Court, the current arrangement as provided under the Constitution? Or do you think that we can have some other arrangement? And if we can have some other arrangement, what type of arrangement should it be? Thank you, my Lord.
I do. You asked me what I think the current arrangement is okay, or it should be adjusted. I think that the current arrangement, in football we say, if it isn't broken, you fix it only when it's broken. The current arrangement has served us well from 1992 till now. It's not broken. You shouldn't fix it. I believe that the current arrangement, see, the Constitution, as we have always said, must be read in such a way. You should read every phrase and every sentence, every word in the Constitution. And then, if you look at the practice, as I said, you as you rightly said, the nomination and appointment and everything is done by the President. But I have told you what goes on in reality. And in reality, the Judicial Council plays a very crucial role. We advise, the Attorney General has a role to play, the Bar Association has a role to play. And so you may not have this laid down in the Constitution, but in practice, this is what goes on. And that's why I'm saying that, as far as I'm concerned, I'm comfortable with the current arrangement of appointing judges. And that is how I see it.
Thank you. Before allowing you to proceed with your second question, I want to remind all of us about Standing Order 88.7, and I read, a member in asking a question shall not address the House, raise any argument, or offer an opinion. So let's keep to these rules, and then we can make progress. Now, your second question, if any.
Mr. Chairman, I have a supplementary question.
Yes.
My Lord, my supplementary question is that, having heard you, and you are convinced about your position, how do we remove the suspicion or allegation that some presidents try to pack the course? How do we remove that one? Even though people go through all these processes, and yet the allegation is that
you are violating the rules that I've just read. So please, my Lord, your answer to the supplementary question.
You say people suspect that in the first place, what is packing the courts? Are we talking about the number of persons appointed to the court or what? Yes. I don't know how people's suspicions can be dealt with, but as far as I'm concerned, as I said, persons have been promoted on the advice of the Judicial Council. If 40 people, names of the current lists, on the advice of the Judicial Council, 41 persons' names were sent to the presidency. And only 4 out of the 41 names were taken out. And even only on the grounds that they had not finished with the background check, as at the time they were because I was sitting on I was pleading with the president that we needed to have these people sworn in so that the legal year could begin with the courts full. But the president, they had not finished with the national security clearance for all of them. In the long run, out of 41, recommended by the Judicial Council, made up of members of the bar, members of the judiciary, members of the Attorney General's representative. These 37 out of 41 names were sent to the presidency, and only 4 were not taken. If anybody sits outside and says that the president has packed the court, how will I be able to convince such a person that it's not the president actually who put the 37 people there? We did. He only took our advice. So it is not as if people's suspicions are going about that. You cannot go about trying to assuage people. You can do that. People will still have their suspicions. One of the questions that I got was, people are saying I got my nomination as a result of 2013. I have explained my way. If people still have that feeling, can I do anything about it?
Thank you very much. Yes, any further questions?
Yes, Mr. Chairman. My second question, my Lord, you have dealt with it partly, but I'm bringing you another angle. Under Article 154 of the Constitution, 1541, if we approve you, which we are going to do, you will become the chairman, because I'll vote for it. the chairman, you become the chairman of the Judicial Council. And under Article 154, you are enjoined as a council.
What is your question?
I'm bringing the question, Mr. Chairman.
Please ask question. I've just read the rules to you. You can address us.
Very well. Simply, what reforms are you going to bring to the table outside the reforms that you have already mentioned? Because you have already indicated some reforms that you are going to do. What other specific reforms are you going to bring to the table in terms of accountability, professionalism, etc., etc.? Thank you.
The Judicial Service mandate is to adjudicate cases and then ensure that the laws, the Supreme Court will interpret the laws, and all these come as a result of adjudication. As I said earlier, and we all agree that one of the problems that we are having now, the crisis, is as a result of people losing confidence in the judiciary. And we have traced it to certain happenings. Like, as I said, we mentioned the complexities of the rules. We talked about backlog of cases and all that. One of the things that that is there, but it is not really nationwide, is the e-justice system. The e-justice has been introduced. It's been going on for some time now, but it looks like the e-justice, which is supposed to help us in so many ways, is only within Accra, and also even within Accra, it is within the law court complex. It is my hope and ambition that we will have a rollout of the e-justice to all the regional capitals by the time that my term is out, by the end of next year, all the regional capitals. The aim is to get e-filing, e-justice to all courts in the country. But that is a long-term thing. My aim is to have the e-justice rolled out in all the regional capitals. And that will be something that will help. And then we always talk about justice in terms of cases that come to the court. We don't talk about justice in relation to even the workers. It is very, very, very important to recognize that apart from the judges, the judicial system is not made up of only superior court judges. Superior court judges, by virtue of Article 71, have their salaries decided by the presidency through the committee and then Parliament. Whilst the lower bench have their salaries tied to normal civil servants. And worst of all, the JUSAC, who actually form the bulk of the judicial service. As a matter of fact, if you look at our numbers, the judiciary made up from magistrates to the Chief Justice, we are just about 511. Only 511. Out of that number, those who form the higher echelons, who enjoy Article 70, Article 71, are the High Court, Court of Appeal, and the Supreme Court. We are not known more than 2 230 or something like that. So if you talk about our salaries in terms of Article 71, you are talking about only a fraction of members of the judicial service. So we also have to think about reforms that should affect the lower bench in terms of salary, in terms of working conditions. Because whilst we strive to get accommodation for judges of the Court of Appeal and the Supreme Court, even some of the High Court judges, even in some regional capitals, they don't have accommodation. As for the magistrates and the circuit courts, the least said about them, the better. Because you go to some places and they are renting the most beautiful house. And if before you are aware, that most beautiful house belongs to a perennial litigant, perpetual litigant. Somebody is almost always in your court. So you find it impossible to even work. You understand? So we should also be thinking about, whilst we are thinking about clearing the backlog, doing that, we should be thinking also about the staff. And that is what I mean to do. I want to have a proper discussion of the terms and conditions of the terms of engagement of the lower bench and the staff. That is something that I will make my personal project.
Thank you very much. Yes. Any more questions?
Chairman, that will be all for now. Thank you very much.
Well, thank you. You said that will be all for now. I believe you won't have the opportunity to ask questions again. We are now moving to the leadership. And I'll plead with the leadership that the 3 questions rule would apply to us as well. So, Honorable Majority Leader Mahama Yariga, you have the floor.
Thank you very much. Let me also congratulate the nominee, Acting Chief Justice, for his nomination to occupy the position substantively. I'm sure you sat through and you listened to the engagements between myself and the minority side. I had no intention of preventing anyone from freely expressing themselves. I just wanted them to do so in accordance with our rules so that there can be sanity in the way that we conduct business. I think the gravamen of their case, which I would have preferred that they sat here and actually, because I know you are very capable of providing them with a response, is that they question whether it is proper for you to be taken through the vetting process because there are a number of suits pending challenging the removal of the previous Chief Justice. They are asking what the implications for stability in the judiciary will be, assuming that those challenging the propriety of the removal of the previous Chief Justice succeed in their claim. what will be the nature of the enforcement of the reliefs that they are seeking, and etc. So basically, the question is, do you think that it is proper for us to go through this process whilst these suits are pending?
Thank you, Honorable Chair. I think yes, it is proper. That is the first basic answer. It is very proper. It is a constitutional duty that Parliament is performing. And as at now, there is no order from any court of competent jurisdiction stopping you from performing your constitutional duty. The President has nominated somebody for Parliament to vet the person for the appointment of to the position of a Chief Justice. Vetting of the nominee is a constitutional duty imposed by you by the Constitution. It's a duty imposed on you by the Constitution. So if you have to perform it, nothing, and I think absolutely nothing, stops you from performing your constitutional duty. You see, in the years gone by, when cases like Baffoe versus the Bank of Ghana, which I authored, actually, were written, the learning was that, and the practice actually was that when an application for injunction or when there's an application for injunction is pending, then you hold your hands. So there were situations where persons will rush to court to file a writ or file an application for injunction, and if you go against, even without any order from the court, you went ahead to do what the injunction was being sought for, then you'll be cited for contempt. And cases like Baffoe versus Bank of Ghana, Cito and other things came up and said that that was right. That was it. But the learning now, particularly after the case of Vincent Assefuwa versus the Attorney General, I mean, it's an unreported case. It was done fairly recently. The learning now is that if there is a constitutional duty to be performed, until and unless there is an order from a court of competent jurisdiction, no constitutional body is prevented from performing such a duty just because somebody has filed an application for injunction or even a writ. Even the application for injunction may be handled, may be understood, but a writ, when we do not even know when the writ is going to be heard and determined, you can't do that. As a matter of fact, that is constitutional. But let us even look at an analogy. When President Kufuor was declared, when President Mahama was declared, and it was sworn in on the 7th of January 2013, there, it never prevented His Excellency Nana Dankwa Akufo-Addo from pursuing the petition. He did. It also didn't prevent the president from performing his constitutional duty as a president. He did. These two things went side by side until the 29th of August, when the court said the matter was ended in favor of the sitting president So he should continue. And he did continue. If the courts had come to the conclusion that it was, the judgment should go the other way, and that the president should step down for Nana Addo Dankwa to take the seat, that would have been the order of the Supreme Court, and would have been enforced by Article 1 and 1, 2. The same thing would have happened in 2020 when there was this petition. So a constitutional duty that is supposed to be performed, as a matter of fact, some persons are even of the view that even the Supreme Court cannot even come to the Parliament and then make an order to stop a constitutional duty being performed. But that is another matter altogether. But for as long as no order has been made by any court, a constitutional duty will have to can be performed. And I think it is right that we are going ahead with the vetting.
So in essence, there's no court order restraining the president from nominating a Chief Justice?
There's no
and
court
there's
order.
no court order restraining Parliament from processing the nomination of the president?
There's no court order.
And you are here because we have summoned you to come for us to process you?
Which I couldn't refuse to.
Of course, you cannot refuse our summons. You cannot refuse our summons. But the second issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases to be heard. Is that accurate? And why would that be the case?
If this statement is made by, with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here.
If this statement is made by a person who is not a lawyer, I will put it down to ignorance. I will say that maybe the person is uninformed about legalities, so I will pardon. But if a lawyer makes a statement like this, I would think that it is populist and maybe downright mischievous. The Chief Justice does not list cases, and please, my words, the Chief Justice does not list cases for hearing. The Chief Justice empanel judges to sit on cases that have been listed. Cases are listed when they are ripe for hearing. So we have listing, we have cases getting ripe for hearing, and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed. Pleadings get closed with it. Pleadings are issuance of a writ, a response, and then even sometimes we ask you to file memorandum of issues, particularly constitutional cases. So these three things are done, and when they are done, we say the case is ripe for hearing. Then the registrar will list the case, list all the cases that are ripe for hearing, and the Chief Justice will then empanel judges to sit on them. So if it has not been brought to the attention of the Chief Justice that these cases are ripe for hearing, or they are listed, the Chief Justice does not empanel. Now, when a plaintiff issues a writ, and then he is waiting for the defendant to file a response, a defense, there is a time limit within which the response has to be filed, the defense has to be filed. The plaintiff knows this. So if within that period, the defendant doesn't file a defense, he has every right to move the court for certain reliefs. But before he can do that, he goes to the registry to make a search to find out whether a defense has been filed. If he finds the defense has not been filed, then he can go ahead and then move a motion for judgment in default or whatever. But that is what a diligent plaintiff does. So if a plaintiff issues his writ, and then he's told that it has been served, and so the defendant is supposed to file his defense within this period, then he goes to sleep, waiting for the defendant to file, and he doesn't file, and then the defendant now comes with application for extension of time within which to file defense and all that. The defendant, the plaintiff, who at this point in time may be described as being indolent, cannot be heard to say that the Chief Justice is not empaneling. The Chief Justice doesn't, seriously, but for the social media phenomenon in the social media where lawyers put writs in the social media, the Chief Justice may not know of any case, we may not know that any case has been filed until it is listed and he empanels. So he may not even know that somebody has filed a writ, somebody has filed a defense, or somebody has filed anything. But these days, because of social media, some lawyers, even before they file the writ, they put it in the social media. That is what, but that is not official. A Chief Justice cannot start empaneling, assuming it came into the papers tomorrow, that these cases have been, they are ripe for hearing. The Chief Justice cannot, on that strength, empanel judges. The Chief Justice doesn't deal with the social media that way. So if any lawyer, worth his salt, makes a statement to the effect that the Chief Justice is not empaneling persons to sit on a case because of something he stands to gain, it is rather mischievous. Then it is tagged with, the statement was that the Chief Justice was in a hurry to empanel persons to sit on the application for injunction. When you file an application for injunction, you are given a date. The return date is there. So it is ripe. So it is ripe. When you file an application for injunction today and you fix it for, let's say, a week's time, what the registrar is saying is that the respondent will be served immediately and then he has to respond, all within that time. So when the Chief Justice gets the application, he starts empaneling based upon the return date. So it's not as if the Chief Justice is in a hurry to empanel for applications, but wasting time or refusing to empanel for substantive rates. The substantive rate is not ripe for hearing. It hasn't been brought back to attention, and I cannot empanel judges for that purpose.
Thank you very much. I think that I'll convey this teaching in procedure to the minority. I'm actually asking the questions on their behalf. Just so that they see that we're not running away from anything and we're not afraid of anything. I mean, and that was what I kept telling him, that the same issues that you want to do press conference and not give the person the opportunity to respond. Sit here and ask the person. And he will give you answers, because I'm sure he's capable of giving you answers. And so I've asked all the questions, the critical questions that was the substance of their statement. And clearly, if they were sitting here, they would have seen that they really have no basis. And, you know, at most, clearly a populist gimmick. My Lord, you were involved in this case of Adomako Anani versus Nana Owusu Ajimang. I think you, Justice Wood, then presiding CJ, Ansa, Yeboah, and then Akamba. What is interesting is what Justice Wood said, then CJ, that the often quoted legal maxim, justice delayed is justice denied, coined by the British politician William Gladstone, is no mere cliche. The right to fair trial is in a timely manner is neither a courtesy nor a favor, but a fundamental right. Protracted delays in the administration of justice impact negatively not only on those who assess the courts, such as the victims of crime, accused persons who are acquitted at the end of their trial, parties in civil proceedings and their privies, lawyers who practice before the courts, but indeed the entire justice system. The judicial history of this relatively simple family-related land matter, which was commenced in the High Court, Kumasi, as far back as the 4th of April 1974, provides an insight into the harmful effects of systemic delays in the administration of justice. Regrettably, it has taken 40 long years, a whole generation, for this case to finally find its way into this court, the court of last appeal. We hope court business shall always be managed in ways that will not occasion a repeat of this parody of justice. So this is a case that lasted 40 years. It was a simple family land matter. And you are part of the case. Today we are still talking about delays in the administration of justice. In this age of AI, have you considered how to use technology to quicken the pace of the administration of justice and the resolution of cases?
Thank you, Honorable Chair. I have forgotten the facts in this case, but I mean, you are not even asking me about the facts of the case, actually. But were there any dissents?
There was no dissent. It was a unanimous, I think, decision of the court.
Yes, I mean...
The court was happy that they had finally resolved the matter. It was basically a land matter. But what really happened was that the judges at the High Court kept changing.
Yes.
And so the issues were whether or not, in the light of the changes in the judges, whether the proceedings of the previous judge should just be adopted or whether or not the case should start afresh. And the judges just kept being changed until finally the matter went to Court of Appeal. And so it just lasted 40 years. That's the most important thing, that this case lasted 40 years.
I get Honorable Chair. I think this is not an isolated case. I mean, it is far. I mean, I can't talk about 40 years, but what honorable member means is that it lasted for so long. Yes, I remember I had been cases like that, and I remember there was a time the honorable Chief Justice.
So basically, my Lord, let me just go straight. The question is what are the mechanisms you think? You've said a lot today about how to deal with, ensure speedy trial and etc. But there are structural issues. We have about 5 layers or 4 layers in most cases. When cases start from the lower courts, go to High Court, then to Court of Appeal, to the Supreme Court, that's about 5 layers, okay? Now, can we just reduce the layers? Because the layers mounting up to 5 do not automatically guarantee quality outcome.
Yes, I mean, Honorable Chair, I agree with you, but it all boils down to the rules. It all boils down to the rules. The Constitution gives a person a right of appeal all the way to the Supreme Court.
So can we change the rules and say we are giving you just 3,
Yes.
attempts to get justice,
Yes.
and if at the 3rd attempt you are not satisfied, you just have to live with that, and rather work on the quality of the courts, so that by the time you do 3, anybody looking at the outcome at the 3rd layer can confidently say that what you've really gotten is justice, so you can't waste our time and resources. Yes. Can't we just cut down the number of layers?
That with all due respect, that will be the role of it will be your mandate.
Yes, so because some of those provisions are entrenched in the Constitution. So these are issues that I've raised with the current committee that is working on the Constitution review, that I think that we should cut down on. And then also, can we say that the Court of Appeal should be the highest appellate body, whilst we have the Supreme Court actually serve as a constitutional court?
Absolutely.
Because there's too much caseload at the Supreme Court level,
Absolutely.
Which has necessitated the appointment of so many Supreme Court judges. Because I'm even advocating for a panel to sit in Bolgatanga near Boku, so that I don't have to travel far to have access to justice at the Supreme Court level. Can we just transform our Supreme Court into a constitutional court like the US, like South Africa has? What's your thinking? In view of the discussions going on about amending and reviewing our Constitution.
Honorable Chair, this is a very interesting trajectory that this question is taking. People, in answering your question, we'll have to sway into why the Supreme Court, whether the Supreme Court even needs that number of judges. And it has been said in several fora that I have been, that whether we have a Supreme Court of 10, like 9, like America, or we can go to the minimum of 1 + 9, that is 10, as our Constitution provides, and not go up, is dependent upon the jurisdiction of the court, the Supreme Court. As you rightly said, in South Africa, they have a Supreme Court and they have a constitutional court. In America, all the states have their Supreme Courts, where civil cases or whatever, can go all the way to their Supreme Courts. But when you come to the Federal Supreme Court, it is for constitutional cases alone. Now, in Ghana, we have 7 different kinds of jurisdictions. Each one is as heavy, carries as heavy load as possible. We have supervisory jurisdiction, we have appellate jurisdiction, we have original jurisdiction, we have jurisdiction to deal, review jurisdiction, we have appellate jurisdiction as far as the chief justice matter is concerned, and we have jurisdiction to deal with presidential, and then we have supervisory jurisdiction. So we see at every point in time, and the Supreme Court is made up of very old men like us. So you see, even one of the very first things that every Supreme Court judge, one of the very first things that you say when you get to the Supreme Court is, hey, I thought I was coming to the Supreme Court to relax, not knowing that this place is even busier than the Court of Appeal. It is a statement made by everybody who has passed through the Court of Appeal. The Supreme Court is so inundated because we deal with cases, as you are aware, there is a criminal case, Ali Kasina, started in my village at Goso, and it ended up at the Supreme Court. We have cases, civil cases involving land, and it starts from the Circuit Court to the Court of Appeal to the Supreme Court. We have Magistrate Court cases from the magistracy traveling all the way to Supreme Court, and we sit on them. So this is where the problem arises. There is no way you can have, if you decide to stick to the 10 persons, you have only a panel of 2 panels, and only 1 panel when it comes to constitutional cases. So you can't deal with all these cases. And believe you me, because of the rights attached to, have been granted by the Constitution, that a person has a right to go all the way to the Supreme Court, people are prepared to, and now, you see, now it's even easier. The Court of Appeals are all over. In the years gone by, people will think twice if they have to come to Accra to do appeal cases. Now the appeal courts are right in their region. So they will file their cases there. Then if you are doing a case, the slightest thing that anybody does, interlocutory appeals, you are going to the Court of Appeal. So when it comes to personnel, it is difficult to, as it were, say that numbers should be reduced when it comes to the Supreme Court. Now, your case, the case that you have mentioned, if you look at it properly, if you read it, you realize that it spent, if it was 40 years, it took 40 years for it to be finally addressed. You find that about 35 of that number of years happened in the lower trial court. When the cases that come to the Supreme Court, appeals don't take up to 1.5 years or 2 years. The Court of Appeal, they say it. The simple reason being that by the time it comes to the Court of Appeal, by the time it comes to the Supreme Court, then we already have the bulk of the record of proceedings prepared. And then at the Court of Appeal, it is written submissions, just the written submissions of parties, and then the ruling that is added for it to go to the Supreme Court. So preparing the record of proceedings doesn't take so long. But at the trial court, because of the number of changes in terms of judges, and then in the years gone by, parties had the right to object, to say that no, in the years gone by, both parties and the lawyers had to agree for the proceedings to be adopted. If one of them says, no, I don't want the proceedings to be adopted, then it has to be started de novo. And then even where, finally, even where proceedings were supposed to be adopted, you'll find that the judge might have retired, and there are some judges whose handwriting only they could decipher. I mean, some judges were writing like this. like that. So you find that they cannot, nobody can even read their handwriting to be able to type it. So in the long run, they have to start de novo. And so if a case goes through 4 judges, you know, that one alone is enough. But as I said earlier, there must be a way of tracking cases so that cases that kept so long on the way should be fished out. In the time of Justice George Wood, I remember she caused some judges, some cases to be selected. There were about 20 cases selected, and he selected some judges. I got 3 of the cases. And these were cases that had been on our books for so long, like this. You see, when the cases were given to me, in one particular instance, a file as big as this, it was scary. But I tried to take my time. I had been assigned by the Chief Justice. I tried to take my time to, as it were, arrange the processes to filed. By the time I got to the end, the file was as thin as this. This file, which was as big as this, carried more than 100 hearing notices. More than 100 hearing notices, all piled together like that. So by the time I selected the statement, the writs, the statement of claim, the defense, and then what did they call it at the time? Application for directions. We had a very thin file to go on. Then, one of the things that also lead to delays is the lawyers. When I was in practice as a junior, if there is a case that is going on appeal, and it is time for you to settle records, your senior sends a junior to go and tell the registrar the things that should be included. But now, lawyers don't go there. They set their clerks who go and tell the registrars everything. So everything should go into the record of proceedings, the compilation. Somebody has filed a writ at the High Court. In the course of the trial, he has filed an application for injunction, to which he attached so many copies of other documents. And then there was a response. They heard the matter. There was a ruling. That was an interlocutory injunction. The case has ended. It is going on appeal. If you are prepared the record of proceedings, do you need to include the application for injunction and all its documents? But all these things will be included, making a very bulky record of proceedings. And it is the clients who pay, for the parties who pay for the record of proceedings. And each record of proceedings, each page is sold at a price. So you find somebody's record of proceedings, about 7 volumes. You decide to go through it, and you can actually reduce it to about 3 volumes. Particularly in this day and age where we file witness statements. So all these things add to the delay, transmission of records, and all that. But I must admit, 40 years is over the top. And if AI can help us trace this, we have to, whatever we do to get AI to do it, we should do it.
Thank you very much. I want to congratulate you once again for your nomination and to indicate that your responses have been very illuminating. Thank you.
Thank you very much.
Thank you, Honorable Leader. It's now the turn of my Vice Chairman, Honorable George Kweku Rickett-Hagan. You have the floor.
Thank you very much.
More than 3 questions.
Thank you very much, Mr. Chairman. My questions are actually two, just a view. My Lordship, Paul Baffoe-Bonnie, congratulations.
Thank you very much.
Looking through your CV, I have no doubt in my mind, looking at your background, knowledge, and experience, I have no doubt in my mind, and I believe many Ghanaians, that you are the right person for the job at this time.
Thank you very much.
Now, just as I said, just a view, actually, that I want. Do you take the view that as a country, Ghana, we are churning out too many lawyers in terms of people going to law school? And if that is your view as well, because it's a view of, a school of thought, if that is your view, would you support downsizing the intake to the law school as well as those who go through the bar? Thank you.
Thank you, Mr. Chairman. Honorable Chair. I think I don't agree, I don't share that view that we are churning out too many lawyers. Actually, the word churn gives the impression that we are not training, we are doing substandard work that the products are substandard. But that is not the case. We are also not overproducing, actually. You see, if you go into history, throughout the whole period that we have had lawyers in Ghana, lawyers that the law school has produced, and the lawyers who have come from outside, all put together, from 18th century, Mensa Saba and all that, we're not up to 15,000. 15,000. And that is from 18th century. Out of this, a lot of them have died. A lot of them have migrated. So currently, the people in Ghana who are lawyers, despite the numbers that you see being called to the bar last year and 2 years ago, the numbers are not up to 7,000. The number of lawyers in Ghana are not up to 7,000. And out of this 7,000, less than 5,000 are in private practice. Less than 5,000 are in private practice. And what I mean by private practice is, for example, those who are on the bench are also part of it. Attorney generals, and then the practitioners. That doesn't include those who are in the banks, Bank of Ghana and other places. All those are people who are not even in practice. So you see, if you take the number 5,000 as lawyers in Ghana, and you measure it against the population of Ghana, you have a ratio of 1 to 7,000 citizens. 1 lawyer to 7,000 citizens. Nigeria, they have, I think, 1,500 or 2,500. The UN sustainable is that it should be 1 person to 250. So you see, we are way beyond. We are way above what should be the right thing. And we also have situations, the law is such that the district assembly law, the local government act, expects every local government to have a legal department. And when they say a legal department, not just a lawyer, a legal department. If a legal department, then they should at least have more than one person. Every local assembly, House of Chiefs, all the houses of chiefs. So we have lawyers. We actually need more lawyers. If you are deceived by the number of lawyers you see in the law court complex or plying their trade in Accra, you may be deceived into thinking that there are many. But go to Kumasi. Kumasi has a population as big as Accra, slightly lower than Accra. Or Ashanti region is maybe even bigger than Greater Accra. But the number of lawyers operating in Kumasi, from Kumasi, are 305. Kofori, they are 110. Secondly, and my honorable will tell you the number of lawyers who are in Tamale, Bolga, and Wa. You see, we don't have enough lawyers. So even the ones, the number that we have a maldistribution, geographical maldistribution. So if you see lawyers, and there are so many of the lawyers that came out, who were called to the bar, the people who were called to the bar very recently, there were about 800 of them. I can assure you about 200 of them may never ever step in the courtroom. They just, the headmaster of my school, the best secondary school in Ghana, is a lawyer. And he's been a lawyer for the past 6 years. I asked him why he went to read law. He says, when he retires, which will be doing at the end of November, then when he retires, then he will pick his law, he'll go and do galamsey. No, not the galamsey. The lawyers understand legal galamsey.
Are you talking about galamsey in law?
In law, yes.
Very well.
So you see, and then of the 5,000 lawyers that we have in Accra, so many of them have run to Parliament House. They are politicians now. They don't even come to court. So, my honorable chair, they are not many. As a matter of fact, I believe that we need to expand. We need to expand the admission so that, because now a lot more people are doing the LLB and they are not getting the chance to go to the law school. So there is even, there has been discussion with the current Attorney General, and then we are thinking about a situation where I think there's a government policy in the offing that is aiming at farming the law school program to various faculties so that we get rid of the admission, the entrance examination, and then we find ourselves, everybody who has done LLB can go and do the law. At the end of the day, there will be an examination, and then people will pass out. People will come out as lawyers. So to answer your question, I don't think that there are many lawyers in Ghana. We actually need more lawyers.
Thank you very much. Any further questions?
Yes, Mr. Chairman. Thank you for the enlightenment, my Lord. My second one is also a view. And now let's turn to the Supreme Court itself. Ghana's population is about 34.5 million. Let's say America's population is 10 times that size. We have 19 judges of the Supreme Court here in Ghana to a 34.5 million people. We have 9 to America's 345 million. Isn't that we have too many judges in the Supreme Court? What is your view on that? Thank you.
I thought I had answered this question. I thought I had answered this question.
Honourable members, order.
I thought I had answered this question, but Honourable Chair, I have to repeat what I said. America doesn't have 9 Supreme Court judges. It's the federal state of America that has 9 Supreme Court judges. America has about 351 Supreme Court judges all over the 51 states. You see, and the American Supreme Court, that's the federal Supreme Court that you are talking about as having 9, has only one jurisdiction, and that is interpretation of the Supreme Court, the Constitution of America, of the US. That is, they are what we call a constitutional court. So, but Ghana, our Supreme Court has, as I've said, appellate jurisdiction. The case, the 40-year case that honorable member talked about, finally ended at the Supreme Court. I'm sure even if we were to go into archives, we will find that from there, from the General Supreme Court, the person might have gone or up for review. You see, so the Supreme Court has so many jurisdictions that if we decided to keep numbers at 9, we would not be able to work. We will not be able to work at all. The only thing that we have to, there are 2 things. And either we increase the numbers, 19 may be all right for now, but the way things are going, the way cases are coming up, and the way we are thinking of AI and other things, we may see now cybercrime, everything. There are modern areas that are coming up that we have to empanel judges to deal with. The way things are going, if we don't take care, we might end up with about 25 Supreme Court judges. The surest way of avoiding that calamity is for all of us to come together and maybe through the Constitutional Review Committee, reduce the jurisdiction of the Supreme Court, the various jurisdictions that we exercise. Like Honorable suggested, we could say that every appeal should end up at the Court of Appeal. There shouldn't be interlocutory appeals. There shouldn't be that. There are so many things that can be taken off. If we say that you cannot start any, because you can't start a presidential petition in any court apart from the Supreme Court. By an ingenious way of interpretation, even though all cases can end at the Supreme Court is said that parliamentary petitions can go only up to the Court of Appeal. That was very, very ingenious. And so parliamentary petitions end up at the Court of Appeal. If we could find a way of putting into the constitution that we want to craft for ourselves, so that cases can end at the Court of Appeal. Or, for example, criminal cases can only end up at the High Court or the regional tribunals or whatever. Then we can start thinking about reducing the number of Supreme Court judges. Otherwise, we should be prepared for a situation where we can have 20 or more Supreme Court judges in future.
Honourable Member, do you have any more questions?
No, Mr. Chairman. I just want to thank my Lord, and then I wish him well. Thank you very much.
Thank you very much.
Thank you, honorable members. My Lord, our revered guest, it's now my turn to ask questions. And by our practice and procedure, I don't have limit to the number of questions I'm supposed to ask. However, I have sat throughout the proceedings. I have listened to all questions asked and answers provided. I do not have any question for my Lord. Honourable members, I will then proceed to congratulate my Lord on his nomination as the Chief Justice. And before discharging him, recognize and acknowledge the revered guests, which I will do not in any order, but I will start from the guest list of the Honorable Nominee. We have Director General Prison Service, Patience Baffoe-Bonnie, a spouse of the nominee. Then the following people are the children of the nominee: Sandra Elizabeth Baffoe-Bonnie, Major Felix Baffoe-Bonnie, Engineer Eben Leslie Baffoe-Bonnie. They are the children of the nominee. Then we have brothers and sisters: Mrs. Georgina Konedu Kusi, former Council of State member. We have Peter Baffoe-Bonnie. We have Mabel Baffoe-Bonnie. Then nephews. We have Justice Baffoe-Bonnie, Enoch Baffoe-Bonnie, and Dr. Kofi Bonzi. Family. We have Mary Nikwe, Rosemary Boafo, Commodore Faustina Anoche, Kwame Asaribuedu, Jefta Apau, Esquire. Then we have the representative of His Royal Majesty Otumfo. We have Nana Sampamahini. We have Nana Amantahini and Amantahini. Anantahini. Forgive me if I don't pronounce it well. Typical Aigbe boy pronouncing three names. Then we have Nana Dr. Abura Boatin, Nyinahini in the Ashanti region. You are welcome. Then we have Reverend Father Akes, Christ the King. Reverend Pastor Tete, Assemblies of God. Then we have all students of Konongo Odumasi Secondary School. We have Felix Abuaji, Esquire. We have Justice Kusi Minka, Esquire. We have Koku Chiramantin, Esquire. We have Esuo Yao Benin. We have Captain Collins Fosu. We have Kwame Jebi. We have Kwame Ousu. Honourable members, we also have Marietta Ajewa Brew. The legal counsel to His Excellency, the President of the Republic of Ghana. We have Benedict Bob Derry. Director of Prisons Operations. We also have Francis Omani Ado, Deputy Director General of Prisons, in our midst. Honorable members, don't take offense in the event I do not mention your name. At the back, I have Nana Sangba Jafla II, Paramount Chief of Sampa Traditional Area, also representing His Royal Majesty Otumfo Osei Tutu. We have Nana Baffoe-Bonnie Chichikra II, member of Asante Hini's delegation. Then we have Berima Yao Koda Opon, Monwuri Hini of Achim Ebuakwa Traditional Area. Then we have Togbi Teprehodo the fourth. I've eaten the okra, so I can pronounce this one very well. He is the Paramount Chief of Amfoga, the President of the Volta Regional House of Chiefs, President of the Volta Regional House of Chiefs, representatives from the National House of Chiefs, and is also a member of the Judicial Council. Then we have Nana Dr. Abra Boatin, the Chief of Nyanahini. I think I have announced. No, you have 16. I've done it. Now, back to the tall list containing the Supreme Court, Court of Appeal, and other judges. My lords and my ladies, I will urge the Hansa Department to capture every name that I have pronounced here, preface it with my lord or my ladyship, if I don't pronounce it. We have Gabriel Poma, Justice of the Supreme Court. We have Avril Lovelace Johnson, Justice of the Supreme Court. We have Richard Ajay Frimpong, Justice of the Supreme Court. We have SKA, my very good friend, Asiedu, Justice of the Supreme Court. We have another good friend, Justice Tanko Amadou of the Supreme Court. We have Ernest Gaiu, Justice of the Supreme Court. We have Henry Kofi, Justice of the Supreme Court. We have Yao Asari, Justice of the Supreme Court. We have Justice Senyo Jamope, Justice of the Supreme Court. We have Justice Bright Mensah, Justice of the Supreme Court. We have Justice Kweku Akabofo, Supreme Court. We have Justice Dennis Ajay, Supreme Court. We have Justice Battles Kujo, Supreme Court. We have Justice Hafizata Amaliboba, Supreme Court. We have Justice Johnson Mbila, Supreme Court. No, member of the judiciary. Member of the judiciary. Yeah, Judicial Council. We have Samuel Afote, Judicial Council member. We have Ambassador Ekuya Sana Danso, Judicial Council member. Then I have announced Togbi Teprehodo already, but he's here again, Judicial Council member. We have Dennis Ejiram Fome, Judicial Council member. Now we have Georgina Mensah Dacha, Court of Appeal. We have Jennifer Abnadazi, Court of Appeal.
We have Kofi Akrowia, Court of Appeal. We have Justice Pamela Cranty, Court of Appeal. We have Yao Onyamiye, Jacobo, Court of Appeal. We have Shilaminta, Court of Appeal. Gifty Dacham, Court of Appeal. Professor Olivia Anku Chede, Court of Appeal. Dr. Bampuru, Court of Appeal. Dr. Enes Owusu Dapa, Court of Appeal. Jerome Noble Nkrumah, Court of Appeal. Anthony Opon, Court of Appeal. Jafta Apau, Circuit Court. Gifty Ajay Ado, Court of Appeal. Olivia Oben Ousu, Court of Appeal. Alexander Osetutu, Court of Appeal, and he is my classmate. Cecilia Davis, Court of Appeal. Mariam Samu, Court of Appeal. Mariam A.G. Jawara, Court of Appeal. Sam Obong Diewu, Court of Appeal. Lydia Osei Mafu, Court of Appeal. Charles Wilson, Court of Appeal. Ms. Rosemary Gezi, Deputy Director, Communication, Judicial Service. We have Mr. J.R. Ampon Fosu, Director, Communication, Judicial Service. Honorable members, all the Supreme Court, Court of Appeal, other judges are all my friends. We have Justice Yoni Kulendis, Justice of the Supreme Court. He is also my very good friend. Honorable members, you are all welcome. On this note, I proceed to discharge the nominee after a successful vetting, and to add that my Lord, Acting Chief Justice nominee, would surely hear from the committee. You are hereby discharged. Honourable members, I will ask the members of the committee to remain seated, and I was asked to add that in Parliament we don't clap, but we said here, here. Thank you all for coming. Honourable members, all the executives of the bar. I have seen the president and other members of the bar, former presidents. My own classmate Kokujewu, you are all welcome.